Hi, this is Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on this week's video. On this week's video, we're continuing with our new series entitled, What's the Point? And we just completed Section 1, which included 3 parts. And Section 1 was devoted entirely to important principles related to your physical examination. So in Part 1 of that section, we talked about reflex testing and the importance of reflex testing as a true objective finding in your physical examination. In Part 2 of that section, we talked about sensory testing, and we talked about how sensory testing is laid out anatomically and what is the significance of preserved and intact sensory function and how that relates to your opinions and conclusions for permanent impairment. And then in Section 3, we talked about the important differences in your physical examination that you would do in your clinical practice for the determination of a patient diagnosis. And we compared that to the physical examination procedures that you would do in your QME practice for the determination of the presence or absence of permanent impairments. So that was Section 1 of this new series entitled What's the Point? And if you missed any of those sessions, you can access those sections from our website, and I encourage you to keep up with your colleagues because we're talking about topics here in this series that seem to be commonsensical or sensible, but that may not be intuitive. And so we're sort of talking about what might otherwise seem to be obvious, but what actually is not so obvious when you're engaged and enthralled in the throes of battle, as we sometimes become as qualified medical evaluators. So I encourage you to stay current with these topics and stay up with your colleagues. Now, in today's session, we're starting a new section. This is Section 2, and the title of this section is entitled, What's the Point? And we're focusing on what I refer to as the new QME conservatism. It seems that the more experienced qualified medical evaluators are becoming more and more conservative in their opinions and conclusions. And this seems to be a general trend across all specialties. It simply seems to be related to time on the job or experience as a qualified medical evaluator. It seems that we all start out quite liberal and quite generous in our opinions and conclusions. And then over time, as we become battle-worn and scarred, we become more and more conservative and more cautious in rendering our opinions and conclusions. And I refer to this trending as the new QME conservatism. And in this section, we're going to talk about the new conservatism as it relates to 3 general areas involved with your QME evaluation. Number 1 is the AOE, COE, or causation determination. So that'll be the first thing that we talk about. Second, we're going to talk about the new conservatism with regards to rendering your final opinion as to the level or existence, or I should say the existence and the level of permanent impairment. Seems that QMEs are becoming more and more conservative in the rating of permanent impairment that they're providing, because the QMEs, the new conservative QMEs, consider lower ratings, lower versus higher ratings, to be the more accurate representation and the truer representation of the examinee's true condition on the date of the QME evaluation. And then in the third part of this discussion, I want to talk to you about the new conservatism related to rendering your final opinions and conclusions related to apportionment. And again, along the same lines, it seems that doctors are becoming more conservative and are rendering higher and higher percentages of permanent impairment to be related, or I should say to be apportioned, to other factors, and lower percentages of permanent impairment being related to the industrial injury. So in that sense, when an examinee finally arrives at the permanent impairment evaluation, And if indeed they do present with permanent impairment, the new conservative QME and the new conservative approach is to apportion a great percentage of that resulting final permanent impairment rating to other factors rather than to the industrial injury. Because the new conservative QME recognizes that unless there's other factors present, unless there's some other conditions going on, other things going on, most patients or examinees, whatever you want to call them, workers' compensation, we call them examinees when we see them, but before we see them, they're undergoing treatment, so in that sense, they're patients. Most patients get well with quality medical treatment. And so if the examinee gets to the permanent impairment evaluation and for whatever reason they're continuing to report ongoing symptoms and activities of activity limitations, there has to be a reason for that. There has to be an explanation as to why. Why have they failed to recover from an industrial injury in the presence of adequate and ample medical treatment? And so more and more QME, conservative QME doctors are apportioning a greater percentage of the final permanent impairment to other factors and less to the industrial injury. And I'm referring to this as the new QME conservatism. So I want you to just think for a minute what an impact this could have across the industry as a whole if medical opinions for AOE, COE became more conservative and fewer applicants for workers' compensation benefits were denied those benefits when indeed they don't actually qualify for those benefits, and those applicants are not allowed to enter the system. That could reduce the overall cost of the workers' compensation system, couldn't it? That could make a dramatic impact. Okay, so let's take this a step further. What if the examinee, okay, we do decide the examinee does qualify for workers' compensation benefits, but at the completion and conclusion of their medical treatment, we opine for lower permanent impairment ratings? That could have a dramatic impact on the cost of workers' compensation across the state of California as well, couldn't it? And then finally, for those applicants or those examinees who do have a final permanent impairment rating, what if more and more, or what if a greater and greater percentage of that final permanent impairment was found to be due to other factors rather than due to the industrial injury? What impact would that have on the cost of workers' compensation in California? And what would the combined and cumulative effect of those three decision-making points, decision-making choke points, what impact would those three conservative opinions have on the cost of workers' compensation in California? It would be a dramatic reduction in the cost and complexity of workers' compensation. And for our purposes, it's important that we not get misled or that we not go down rabbit trails. And I want to emphasize that we're not focused on costs here, although costs are a significant concern. What our concern is what's actually true, what's actually happening, what's actually accurate, what's actually the case, what's actually correct, what's actually the truth, or what is as close to the truth as possible. How close to the truth can we possibly come? And I want to share with you what the new conservative QME is considering to be the most accurate and the most streamlined and the most straightforward approach to these three issues: causation, permanent impairment, and apportionment. Okay, so I want to begin today, and let's focus our discussion today on causation. So I'm going to take a break right now, and we're going to come back. I'll have the whiteboard out behind me, and we're going to diagram out a couple of actual case scenarios with some timelines and some dates, and we're going to discuss causation probably in a way that you've never heard discussed before. This is going to be a frank and open discussion among us as a mastermind group between doctors, and I'm sure you're going to find this to be immediately valuable with your very next evaluation. So look forward to being back with you here in just a couple minutes as we begin section 2 of our new series entitled What's the Point? And today we're focused on the new QME conservatism as relates to causation, AOE, COE, the causation determination. Okay, I'm back with you now, and we're talking about the AOE COE causation determination. And we're approaching this in a new conservative approach. Now, the opposite of a conservative approach would be a liberal approach, wherein we simply opine within reasonable medical probability that every single examinee who comes before us indeed suffered an industrial injury, regardless of any of the circumstances that may cloud such a determination. That would be a liberal approach. But today we're talking about the new conservative approach. So let's review a couple of basic concepts from the law that support doctors in their new conservative approach. Now, one of the important legal considerations with regards to your AOE COE determination has to do with what's referred to as the burden of proof. Now, it's Labor Code 3600 that gives us our conditions of compensation liability. In other words, the conditions under which an industrial injury claim is approved. Okay, that begins under Labor Code 3600. And we're going to talk about Labor Code 3600 here in just a minute. But let's talk first about what's referred to as the burden of proof. And I have a couple of references here from the new 2016 Physician's Guide. And it talks about the burden of proof in workers' compensation. So let me read a couple of passages here from the Physician's Guide. And this will set the tone and the philosophy for today's discussion. It says that an important legal concept in workers' compensation is the burden of proof. The burden of proof is on the party that is trying to establish some point by a preponderance of evidence. So with AOE, COE, and causation, it's the applicant, it's the injured worker who's trying to establish the point that, hey, I've been injured on the job, okay? That's their burden to prove, okay? So the burden of proof is on the party that's trying to establish some point by a preponderance of the evidence. And I want you to remember that phrase, the preponderance of the evidence. It says a preponderance of the evidence means, and this is a quote, such evidence as, when weighted with that opposed to it, has more convincing force and the greater probability of truth. When weighing the evidence, the test is not the relative number of witnesses, but the relative convincing force of the evidence. So we're presented with this all the time as qualified medical evaluators. We're presented with evidence on the one hand that we have to compare and contrast with evidence on the other hand. And we do this sort of weighing procedure to find out which of the two sides has the greater convincing force. So in this regard, preponderance of evidence is such evidence presented by the applicant that when weighed with evidence opposed to it, so that would be evidence perhaps presented by the claims administrator, that would be evidence perhaps based on the historic facts, that would be evidence perhaps based upon your physical examination findings. So we have evidences and we have evidences that oppose the evidence, and we weigh those to determine which has the more convincing and is the more compelling and is the more probably true. And we do this all the time, and this is how we make our determinations. We simply weigh different evidences. Well, for the AOE COE determination, it's up to the applicant to prove the injury. They have the burden of proof. So it says the injured worker has the burden to prove that the injury or medical condition arises out of or in the course of his or her employment. Now, this is a critical point that I want to make to you, so let me restate that sentence. It says the injured worker has the burden to prove that the injury or medical condition arises out of or occurs in the course of his or her employment. So the applicant has the burden to prove not the existence of an injury or condition. That's not their burden. See, they can present with an injury or condition, and they do all the time, don't they? Their burden is to prove that the injury or condition arose out of or occurred in the course of their employment. Those are two different things. They don't simply have to demonstrate that there's a condition. Simply having a condition doesn't by de facto and default indicate that it arose out of and occurred in the course of the employment. All the presence of a condition proves is that there's a presence of a condition. It doesn't prove causation. So the injured worker has the burden to prove that any injury or condition arose out of or occurred in the course of employment. And the best way to deny industrial causation for an industrial injury is to prove that there's no condition. But in the presence of a bona fide condition, the question then for us becomes, is it possible that this injury could have arose out of or occurred in the course of employment? And the burden is upon the applicant to prove that. Now, did I say that the burden was on us as the doctor? Many doctors believe that the burden is upon them, but the burden is not on us as doctors. The burden is on the applicant. Our job as evaluating doctors is to view the evidence presented by the applicant, to view the evidence that could possibly oppose the evidence presented by the applicant, simply go through a weighing process and select the evidence or select the opinion with the greater convincing evidence. Okay? Do you follow me? Okay? Now, this burden of proof, let me make another parallel on the burden of proof and relate the burden of proof to another labor code that you may be familiar with, which is Labor Code 4664. This is a labor code that we refer to in our apportionment determination. So let me just make a little parallel between the burden of proof and where the burden of proof actually lies. So Labor Code 4664 says, and you're probably familiar with this quotation, it says, if the applicant has received a prior award of permanent disability, it shall be conclusively presumed that the prior permanent disability exists at the time of any subsequent industrial injury. This presumption is a presumption affecting the burden of proof. Now let me ask you, upon whom does the burden of proof lie to prove that the prior permanent disability did not exist at the time of a subsequent industrial injury? See, the law says that if you had a prior permanent disability award, that disability award stays with you on into perpetuity. And then if you have a subsequent industrial injury, on the date of that subsequent industrial injury, you were already permanently disabled to the degree and to the percentage that you received prior. It's the law. The law says it exists. But this presumption can be rebutted providing there's sufficient burden of proof. Upon whom does the burden of proof lie? And many doctors believe that the burden of proof lies on them, and it doesn't. It does not lie upon us to prove that the prior permanent disability went away, that it was rehabilitated, that it disappeared, that the examinee returned to their prior level of function, the burden of proof lies upon them, the applicant. So doctors, what's the point here? Here's our first point. Don't advocate for examinees by assuming their burden. The burden lies upon them. Do not assume the burden for causation. Do not assume the burden with regards to apportionment. They have an advocate. They don't need us to advocate. Most of them already have an advocate in the form of an applicant attorney. Let the applicant attorney, or in the case of an unrepresented injured worker, let the judge advocate for the examinee. Don't, as a qualified medical evaluator, advocate for the examinee, and don't assume their burden. Okay? So, back to AOE, COE determination. Now, so the burden is upon the applicant. They need to prove their burden by a preponderance of evidence. This raises an important question for us as evaluators. What would you consider to be evidence? What would you consider to be convincing, compelling evidence, such that when weighed against evidence opposing it, would lead you to opine for an industrial injury, would lead you to approve or authenticate a claim for industrial injury? What type of preponderance of evidence would you require? Interesting thought, huh? So let me draw a couple of additional parallels for us. And let's refer to Labor Code 3600 first as relates to post-termination claims. Post-termination claims. Now the law tells us exactly how to handle post-termination claims. This is in Labor Code 3610. So let me just read this to you. It says that except for psychiatric injuries, where the claim for compensation is filed after notice of termination or layoff, including a voluntary layoff, and I have an example of that for you here in just a minute, and the claim is for an injury occurring prior to the time of notice of termination or layoff, no compensation shall be paid. This is the law. Okay, this is the law. It says no compensation shall be paid unless the employee demonstrates by a preponderance of the evidence that one or more of the conditions apply. And I'll tell you the conditions in just a minute. But again, the burden of proof is not on us as the doctor. It's on the employee, who has to demonstrate by a preponderance of the evidence. Now, in a post-termination claim, here's how a post-termination claim works. We have an examinee who works and is then fired or laid off or terminated in some fashion on a certain date. After that date, they file a claim for industrial injury and say that before they were fired, they suffered an injury and they want workers' compensation benefits. The law says that does not fly. Why would the law say that this does not fly? Because the legislature and lawmakers have long observed and long realized that when examinees or employees are terminated, they become retaliatory against the employer. And so post-termination claims are simply viewed as a way to retaliate against the employer for the termination or the layoff. It's the law. This is not subject to our opinion. This is not subject to reasonable medical probability. This is the law. Now, if the examinee can demonstrate by a preponderance of evidence a couple things, then the claim can fly. What are those things? Well, number one, that the employer has a notice of the injury, a notice, prior to the notice of termination or layoff. That makes sense. If the injured worker goes to the employer and says, hey, I was hurt on August 1st, and the employer says, well, that's great. Well, we're going to let you go on November 1st. The employee says, well, I'm just telling you, that before you told me, I told you. And there's notice. Number 2 is that the employee's medical records existing prior to the notice of termination or layoff contain evidence of the injury. So evidence, evidence, evidence in the form of documents, in the form of a notice of injury, or in the form of medical records that evidence the injury. So let me give you a couple of examples of post-termination claims, and we're going to relate those to claims that don't involve termination. But we're going to see that the same criteria apply, that the burden of proof lies on the applicant. Okay, so imagine this. Let me get my notes. With a post-termination claim, post-term, what happens is we have an examinee who's working along this timeline. And then for whatever reason, they're terminated, they're laid off, they're fired. And then after a period of time, and this could be 2 weeks, a month, a year, I've seen every possible scenario. After a period of time, they come and they say, hey, back here, before I was laid off, I had an injury. And the case I want to share with you is an examinee who was terminated on 3/1/15. Okay, he's working along, terminated on 3/1/15. On 4/1/15, he makes the first report of an injury after seeking an attorney, and the attorney sends him for medical care. This becomes the first reporting of an industrial injury 30 days after being terminated. And what the employee stated is he stated that on 2/23/14, 14, not 15, 14, 13 months prior, he had an industrial injury. He never said anything in February. He never said anything in March, April, June, July, August, September, October, November, December, January, February. Only on after he was terminated, he didn't say anything, didn't say anything, didn't say anything. Only after he consulted an attorney and was referred for medical care did he report an injury more than 14 months earlier. Now, Labor Code 3600 says that this claim, this type of claim, this post-termination claim, does not fly. Legally, it does not fly. These cases can be denied unless medical records in this time period prior to the layoff contain evidence of the injury, or if the examinee or the employee has given notice of the injury to the employer prior to the date of layoff. There were no medical records. There was no notice. The applicant, the examinee, failed to satisfy his burden of proof, and this claim was denied. Now, we get these cases all the time as medical evaluators, and our job is to determine the medical facts. But the law tells us that some evidence of the injury is required. If the law requires some evidence, let me ask you doctors, what type of evidence would you require? What minimal evidence would you require before you put your opinion for an industrial injury? What would it take for you to overrule the law and opine for an industrial injury? Would you do it simply on the basis of the applicant's testimony, or would you require some form of documentation, some form of medical records, some form of incident? Again, we're simply taking evidence and weighing the evidence. And in the absence of any supportive evidence, in this case, the examinee cannot provide any supportive evidence, it's a simple matter to opine against industrial injury consistent with the law. Let me share with you another case. Now, this other case deals with not a termination, but a voluntary layoff. Voluntary layoff. So this is a case that involved a 60-year-old dentist. 60-year-old dentist said that on 12/31/14, she was unloading dishes at home from her dishwasher. And she twisted weirdly and felt a sharp pain in her lower back and had an acute episode of lower back pain. On 1/1/15, New Year's Day, she sought medical care at a local emergency room, and following 1/1/15, she never returned back to work. Rather, she pursued medical treatment for the lower back as well as other health concerns, such as enchondroma of the finger, such as neck pain, such as knee arthritis, a variety of conditions in addition to the lower back injury. And so she treated on a non-industrial basis until approximately 10/1/15. 10/1/15, she consulted with a disability lawyer to attempt to obtain Social Security disability benefits. This attorney suggested to her that perhaps some of all of these painful conditions could have been related to her employment as a dentist leading up to the episode of acute lower back pain on 12/31/14. And so on 10/1/15, this was the date of first reporting. Date of first reporting. Okay. What does the law say about this? It says that a post-termination claim, including voluntary layoff, does not fly unless there's evidence of an incident of injury of which there was none, unless the employee's medical records prior to the date of voluntary layoff contain evidence of the injury, and there were none. This was simply a non-industrial lower back sprain strain that occurred on New Year's Eve in the employee's home, for which she claimed a cumulative trauma, period of trauma leading up to and contributing to the final straw, which broke the camel's back on 12/31/14. I opined in this case that the applicant was not able to provide any evidence of an industrial injury, whereas the opposing evidence was strongly suggestive that she injured herself at home on a non-industrial basis and had a variety of other non-industrial conditions that were a concern to her, for which she needed to pursue medical treatment, but that were not related to the industrial injury in any industrial activities in any way. So let's bring this to a conclusion, and let me just ask you, if a post-termination claim involves a date of injury, it involves a date of layoff, and a date of report, most of these post-termination claims involve an injury back here that was, number one, was unwitnessed, and number two, was not reported. In fact, the first report is not until after the date of termination or layoff. So this is generally unwitnessed with no report. Okay? So with post-termination claims, the law is clear as to how we handle this. These claims are simply denied. Well, don't we get other types of cases, not post-termination claims, that are denied? We do. We get denied cases all the time. How do we handle those cases? Well, let me ask you, does it really matter to you if there's a termination or not? What if there's no termination? What if the examinee is just working and then on such and such a day they come to the employer and they say, hey, back here, I didn't tell you at the time, and there was no one there to witness it, but I'm telling you now that I hurt myself back here. Now, in a post-termination claim, there's certain criteria required to approve this claim. There has to be evidence of the injury. Well, what about in a non-termination claim? The law doesn't exactly describe this, but it's my opinion that the situation is analogous to a post-termination claim. There must be a preponderance of evidence to cause you to opine against the opposing evidence. What's the opposing evidence? The opposing evidence is, hey, did anyone see you do that? No. Examinees will tell you, or they'll say, well, yeah, my coworker, he saw me, and he'll write a statement that says he saw me have this injury. The next question is, well, do you have a statement? Do you have some evidence to contribute to your preponderance? Or is it simply that you can get a statement? Go ahead and get me the statement. Or do you have a statement? There's no statement. It was unwitnessed. There was no report. This evidence strongly opposes the applicant's testimony, because most examinees, most applicants who have a sincere, bona fide incident of injury, they know to report this incident of injury. They know that this is company policy, that when you have an injury on the job, you report it immediately, so that we don't get into these gray area confusions and complications. Okay? Let me ask you, what is the minimum evidence? If there's no report, what would you require? Applicant says, I wrote an incident report and I put it on my supervisor's desk. Okay? Have you ever heard that one? What's the next question? Did you hand it to the supervisor? Did the supervisor sign it and give you a copy? Do you have the incident report? No, I wrote an incident report and I put it on his desk. And I came back later and he wasn't there. What happened to the incident report? I don't know. You don't actually have an incident report. There's no report. There's no evidence. There's no preponderance of evidence. Doctors, you must opine on the side with the greater convincing weight of the evidence. And an applicant's testimony is rarely sufficient to contradict or contravene the opposing evidence of an unwitnessed incident with a delayed reporting. In a post-termination claim, it's simply the law that these claims get denied. In a non-termination claim, my suggestion and the point is that we handle these exactly the same. We make a list of the two sides of evidence: evidence for an industrial injury, evidence that opposes an industrial injury, and we simply opine on the side that has the greater convincing evidence, even though that side may, in certain circumstances, be an unpopular decision with the examinee. Okay, doctors? So, let's see. I have one more case to share with you. Very simple case. Non-termination claim. This was a restaurant worker who on 5/15/14 was working. Later that day, 5/15/14, same day, the applicant went home and called the supervisor by phone and informed the supervisor by phone in a non-face-to-face meeting that earlier in the day she was working and she felt a twinge in her back. And she continued working and didn't think much of it. But later on when she got home, she felt the pain increase and she felt that she must report it. Again, we have an unwitnessed incident. Couldn't have been too major of an incident because the examinee continued working and continued with the remainder of her shift. And there was no report at the time. So doctors, can you see no report? Can you see that the presence or absence of an industrial injury at this point in time, in this case, becomes a question of fact? It's not a medical determination, actually. It's actually a question of fact. The fact, did it occur? Did it not occur? We don't know. We weren't there. We simply have to ask ourselves, what is the evidence for an industrial injury? What is the evidence against an industrial injury? And we decide accordingly. Is the applicant's testimony that there was an injury, even though it was unwitnessed, even though they didn't say anything, is it enough to cause you to open up a claim for industrial benefits, temporary disability benefits, medical treatment, permanent impairment benefits down the road, benefits, thousands and thousands of dollars of benefits? Is it sufficient to overcome the fact that this was not seen by anyone, the fact that she didn't report it at the time, the fact that she handled the matter at home in a non-face-to-face telephone call? In other words, did not have a face-to-face meeting with the employer here. And I can't decide this for you, doctors. I'm simply reminding you of how to analyze these types of difficult causation decisions. And that is, we simply take the evidence as is presented to us by the applicant and weigh it against the evidence that would seem to contradict the applicant. And in this case, the applicant had actually no evidence other than their testimony. Now, do we know that examinees and applicants in the workers' compensation system sometimes exaggerate, sometimes fabricate claims, sometimes file fraudulent claims? Is it sufficient for you to simply have the applicant's testimony cause you to opine for an industrial injury? And I'm encouraging you to take a new conservative approach, and that is to deny the industrial injury until the applicant can establish more proof. Don't you establish the proof. Let the applicant assume their burden, which is the law, and prepare evidence to substantiate their claim. So doctors, I hope this helps you. We see so many cases that are denied claims. And in these denied claims, we're asked to make a causation determination. Well, how do you do that? Is there an exact science? Well, it's my opinion that there's an exact science is evolving. And it simply requires that we step back and take a look at the larger aspects of the case. Was it a witnessed incident? When did the examinee report it? What are the facts that support an industrial injury? What are the facts that oppose an industrial injury? And regardless of how much you like and love the applicant, if the facts tend to be more convincing against an industrial injury, that's the way you have to opine, because that's the opinion that you're most able to explain and most able to support with how and why reasoning. So in this manner, if an examinee does not actually qualify for workers' compensation benefits, we opine accordingly. And this saves so much trouble and so much cost and so much administration. And in our next session, we're going to talk about a similar approach with our permanent impairment determination. And in our session after that, we're going to talk about a similar approach with our apportionment determination. So doctors, I hope this helps you when it comes time to make your difficult causation determinations. So that concludes today's video. I look forward to being with you next week as we continue our new series entitled What's the Point? And in this section, we're dealing with the new QME conservatism. So I hope you enjoyed today's discussion. For now, this is Dr. Perry Carpenter. I want to thank you for joining me today, and for now I'm wishing you best of success in your career as a qualified medical evaluator.